Bishop on air. Good morning. A lot to tackle here, especially when it comes to litigation against Illinois' gun and magazine ban. A stack of lawsuits now in front of the U.S. Supreme Court dealing with this issue. And I've talked to three of the major players from several different cases. So we'll be sharing that with you here with Bishop on air. Of course, like, subscribe, hit that notification bell. Anytime we go live, you'll be notified, hopefully, if the algorithms are correct. And you can join us as we broadcast across the intertubes, be it on YouTube, X, Facebook, also on Rumble. So be sure to tune in and join us as we give you the latest on what's going on with the gun and magazine ban in Illinois. With now, there's 4 cases in front of the U.S. Supreme Court, 1 from Maryland, 3 from Illinois, 2 different appeals court circuits. So let's get to it. All right. I talked with Alan Gottlieb from the Second Amendment Foundation. I talked with Hannah Hill from the National Association for Gun Rights, and also Richard Pearson from the Illinois State Rifle Association. Also just got off the phone with Todd Vandermeide. Didn't record that, but he provided some more context as to what's going on here. And if you check out his YouTube channel, you can watch more of that. And of course, that's Freedom's Steel. So a lot to tackle this morning. Good morning to everybody checking into the chat room. JL, good morning. Chubby Guy Customs, Patrick, James, Randall, George, Dave, David, Jerry, John, J-Boy. John, did you get your thing yet? Did you get your patch that I originally sent back in October? That U.S. Postal Service messed up. Roman, good morning. Tom, Tenebris. All right, sweet. John got it. Good. Good to hear. U.S. Postal Service is good for something. Mike, Marengo Guns checking in. Morning. So, yep. Here we are. Take a brief breather. Say that 10 times fast. Brief breather. Dimitri, good morning. Chris, AS3, SXP, Ed. Appreciate you guys being here each and every weekday morning. Dr. Frank Melton, good morning. Or is it Fark? No, it's Fark. All right, stay tuned. We've got a ton to tackle here, all right? Just one segment, but it's going to be chock full of those involved with the gun and magazine bans and what exactly we're going to be looking at moving into the possibility of the U.S. Supreme Court taking stuff up. So stay tuned. That's here with Bishop on air. A stack of lawsuits against Illinois' gun and magazine ban now in front of the U.S. Supreme Court with a motion for writ. And that's to have the U.S. Supreme Court hear the cases. And what makes this different than previous attempts at trying to get the U.S. Supreme Court to intervene in looking at Illinois' gun and magazine ban? Well, I talked to the experts who are involved in all of this, from the National Association for Gun Rights to the Second Amendment Foundation to the Illinois State Rifle Association. And we bring that to you now here with Bishop on Air. Good morning. Hopefully you check in with us live and join the live conversation. Tons of people there having talks with each other. Also, be sure to check out bishoponair.com, where you can join the Discord server as well. But let's go ahead and get on into this with the people involved in these cases. And let's start with the Second Amendment Foundation. I chatted with Alan Gottlieb yesterday about ultimately what his organization's doing with the case for Harrell v. Raul. And here's Alan Gottlieb talking about how this filing is different from previous filings to the U.S. Supreme Court filed yesterday.
Well, it's current law that we're challenging. I can't say what makes it different. The Second Amendment Foundation filed a cert petition with the Supreme Court over the Maryland assault weapon ban last week, which has been kicking around longer than the Illinois one. And now we just filed the one on Illinois. So the Supreme Court now has two cert petitions before it challenging the so-called assault weapon bans. And with the two of them on their plate now, we're pretty sure that we're going to get considered.
So with this case, you've got the filing that was made on Gottlieb talking about what they're ultimately arguing here, especially with the lower courts, Seventh Circuit Court, seeming to characterize AR-15s as military use firearms. Is the lower court thumbing their nose at the Supreme Court?
We believe they are thumbing their nose at the Heller, McDonald, and Bruin precedents at the U.S. Supreme Court. In our opinion, there's no historical data that shows that these type of weapons, should have been banned. The founding fathers, I think, considered these things at that time. There's no precedence. The language is pretty clear in the Second Amendment. These really aren't military-grade weapons. They only fire a semi-automatic. They don't fire a fully automatic. We believe that the Supreme Court is going to rectify this situation and declare these so-called assault weapon ban laws unconstitutional.
And again, talking with Alan Gottlieb from the Second Amendment Foundation yesterday after it was announced that they have filed with the U.S. Supreme Court challenging Illinois' gun and magazine ban after the Second Amendment Foundation filed with the Supreme Court to challenge Maryland's gun and magazine ban. So there are multiple challenges in front of the U.S. Supreme Court dealing with this issue. But I asked Alan about the numbers in Illinois, where you've got registration about 1.4 some odd percent of the total FOID card holders. You're looking at, before the December 31st deadline, 29,357 individuals completing an affidavit saying that they own banned items. And then after that January 1st deadline, these numbers have yet to be updated. Just doing a refresh here, and it's still at an additional 6,262 individuals who have filed. And again, that's of the 2.4 million firearm owner identification card holders. I asked Gottlieb about what this means for, this measure directly impacting gun owners. And if gun owners aren't complying, what does that say about the effectiveness of this law?
People impacted by these gun ban laws surely don't believe these laws are constitutional. And as a result, you can see from the registration data that the compliance rate is close to zero.
So what do we do, though, with the Southern District case? We've been tracking that, and we will continue to track that here with Bishop on Air. On Friday last week, the judge issued a schedule for February 28th for the various plaintiffs' lawyers to have a conference with the judge to talk about moving forward on the merits and looking at the evidence that they want to present and the witnesses and the testimony they want to present. In that case, moving forward on the merits. This after the Southern District of Illinois last April issued a preliminary injunction that was ultimately put on pause by the Seventh Circuit U.S. Court of Appeals before they ruled in favor of the state. So you've got the Southern District now saying, okay, all preliminary issues aside, let's get to the merits on this. How is that going to impact the filings in front of the U.S. Supreme Court?
Well, I believe that all these cases are going to be heard by the U.S. Supreme Court. So they're probably going to consolidate a significant number of these assault and ban cert petitions all in one fell swoop and take the responsibility to set these lower courts straight, that they can't thumb their nose at the U.S. Supreme Court prior decisions.
But should the Southern District be on pause while we await whatever outcome from the U.S. Supreme Court in whether or not they're even going to take these cases? Because I think that's important here. They just filed with these cases.
Well, it could very well put it on pause. And again, the Maryland case that we just filed last week might get to the Supreme Court quicker than the Illinois case. But if they take any one of these assault and ban cases at the U.S. Supreme Court and rule it in our favor for constitutional rights, it's going to knock out all these laws.
So Alan Gottlieb, of course, with the Second Amendment Foundation, they are plaintiffs in the Harrell case. Also in the Harrell case, because, again, you got 3 Illinois cases that filed for cert requesting the U.S. Supreme Court to hear their cases. 3 of them filing yesterday on top of the Maryland ban challenge being filed last week. So you've got the Harrell case, you've got the Barnett case, and you've got the Beavis case. That's out of the Northern District of Illinois. So these 3 different cases from Illinois going in and asking the U.S. Supreme Court to hear the case. As part of the Harrell case, the Illinois State Rifle Association Executive Director Richard Pearson, I also connected with him yesterday to get his thoughts on the stack of lawsuits now requesting the U.S. Supreme Court to take these cases.
Right, which makes me very happy because the Supreme Court will then get the idea that people are concerned about this, and maybe they'll take one of the cases or all of them. And probably, my guess is they probably take them all at once and hear them all at once.
But what do we do about that Southern District case, which Harrell is a part of? Pearson says that he foresees that, they could slow that case down possibly.
Well, because it takes out all these cases. I mean, everything is going to stop now that these cases have been appealed to the Supreme Court. So the cases in the lower courts probably are going to wait until the Supreme Court makes a ruling.
But the question there seemed to have been addressed. When was that? Earlier this year, whenever the Southern District of Illinois, Judge Stephen McGlynn was hearing from plaintiffs. Plaintiffs, if you recall, and you look back at the video archive, plaintiffs were requesting a stay on the Southern District case on the merits. And a stay essentially says, let's put it on pause. Because the plaintiffs said they were preparing to file with the U.S. Supreme Court. But Judge Stephen McGlynn, he said, no, we're going to move forward with this. And even Thomas Magg with the Langley plaintiffs, and I think that they're still lingering out there as to whether they're going to file cert with the U.S. Supreme Court. But even Thomas Magg said, even if we file for cert with the U.S. Supreme Court, that does not mean that the U.S. Supreme Court's going to take the cases. So it would be conducive to move forward with the merits and to go through those steps with the merits of the case. But Richard Pearson...
If there's a case pending before the Supreme Court, all the other cases get slowed down or stopped or wait.
And I just realized that my live stream did pause, so hopefully you guys are back into it. And this is also why we record things locally, so we can upload them in the morning and get it out to you. So if you got interrupted with the live stream, be sure to check back with the recorded segments that we will upload. But more from Richard Pearson from the Illinois State Rifle Association. What else should listeners know about where we're headed with all of this?
Well, I think they need to wait and see what happens. We got a lot of cases all across the country. I mean, you got the Maryland case, we got the California case that is out there, and so we've got ours, and we got the National Shooting Sports Foundation case, and now it looks like we got National Gun Rights going up with the Beavis case. So, but we also mentioned the Beavis case in ours, but anyway, so. There's a lot of stuff going on right now, and I'm looking forward to get this resolved.
So we'll talk with the National Association for Gun Rights. I'll share the conversation I had with Hannah Hill from yesterday with you in just moments. But with the Illinois State Rifle Association, did want to just put this in front of you as well. They do have Illinois Gun Owner Lobby Day scheduled, and that is set for April 18th. And they've got a variety of speakers lined up. It's going to be in Springfield, starting at the Bank of Springfield Center. So the arena there in Springfield. And again, April 18th. It starts at 10 o'clock. And then you've got the march through the state capitol to the Capitol building and a variety of other events. So that's, again, April 18th. 2024 coming up. We'll talk with Richard about that more in the future here with Bishop on Air. But again, you've got the Harrell case that filed with the Second Amendment Foundation, the Illinois State Rifle Association. You've got the Barnett plaintiffs that filed with the U.S. Supreme Court, and both of those are in the Southern District of Illinois right now. But now they're asking for the U.S. Supreme Court to rule on the merits of the case. So what about the Northern District case? I chatted with National Association for Gun Rights President Hannah Hill, and she talked about the Beavis case and how, listen, they've gone to the U.S. Supreme Court 2 different times to ask the U.S. Supreme Court to intervene in the case. But since now the 7th Circuit U.S. Court of Appeals has ruled in favor of the state and issued the mandate, which I think is important because they can't move forward with the next steps until that mandate was issued. And that was issued earlier this year off the November ruling that the 7th Circuit U.S. Court of Appeals made. But Hannah Hill, she talks about the difference of yesterday's filing from the 2 previous filings that they had made.
Right. Those 2 attempts were emergency appeals, right? What we were asking for was not a ruling on the case itself, but rather a temporary emergency stay of the underlying law and ordinance. What we're asking for now is an actual ruling on the case. We're appealing the 7th Circuit's ruling, that the denial of preliminary injunction, the ruling that said basically that AR-15s aren't guns under the Second Amendment, because that's the only way they could figure out how to uphold the assault weapons ban. It's officially an appeal for certiorari. So the Supreme Court rarely takes emergency appeals. So neither of those attempts, when we filed them, they were both Hail Marys, and we weren't that surprised when the Supreme Court said no. However, both of those got more traction than we had expected, which leaves us very hopeful for the official cert petition that we just filed today. So yeah, we're appealing on the case itself now. And this is something that we have every hope that the Supreme Court will look at.
So with the ongoing filings here, when I chatted with Hannah Hill yesterday, talked about the difference here and also the different circuits that are involved, because you have the Maryland case also in on this. And now you've got that with 3 other cases from Illinois challenging bans on semi-automatic firearms.
Well, it should matter. It should weigh heavily with the Supreme Court, the fact that they've got multiple lawsuits out of 2 separate federal circuits on the exact same issue, right? So we don't have a circuit split. And the reason we don't have a circuit split is because the only states that actually ban assault weapons are the ones where there is a concentration of liberal politicians, including in the judiciary, which means the only places that pass these laws are going to be in places where it's unlikely you'll be able to succeed in getting a court ruling that's going to overturn those laws. So that makes it hard to get a circuit split. So what we have is the next best thing. We have pending petitions on this exact law coming from 2 different federal circuits. Another thing that we've emphasized to the court in our petition is that in no contested case over assault weapons bans or magazine bans has a court ruled against the ban, right? So we are 13-0 for assault weapons ban rulings where the ban itself is upheld in violation of Bruin and in violation of the Supreme Court. What we try to emphasize as well is that this is a very serious thing, and it points to a very concerning pattern in the lower courts, much like they did in the days following Heller and McDonald in 2008 and 2010, when we had those awesome Supreme Court rulings that upheld gun rights. The lower courts systematically ignored and defied those rulings, found a way around them, and began ruling against gun rights, just as if those rulings, those precedents did not exist. We are on that track now with Bruin, and it's going to be up to the Supreme Court to step in and say, no, we meant what we said when we said that the Second Amendment is not a second-class right subject to an entirely different body of different set of guarantees as the rest of the Bill of Rights guarantees as well. So that's kind of what we're hoping will happen. We hope that the fact that there are so many, particularly, like I said, coming from multiple circuits, sitting before the Supreme Court at the same time, that will make it harder for the Supreme Court to say no. And yeah, I mean, it would be great to see the Supreme Court just consolidate them all. They might as well. It's the same issue. The issue is, can the Supreme Court, or sorry, can state governments and local governments ban guns that are in common use, right? And we're asking as well in ours if the Heller ruling can be cabined to the actual facts that were under consideration with that ruling. In other words, is it true that if a weapon, whether it's a handgun or a rifle, if it's in common use for lawful purposes, is it true that there is no way that a ban of that gun can be constitutional? Because that was the holding of Heller. But that holding was specifically applied to handguns. What the Seventh Circuit tried to do is say, well, it was only handguns, so you can't apply it to rifles as well. And so we've asked the Supreme Court to weigh in on that also.
So talking with Hannah Hill yesterday, also asked her about how Robert Beavis is holding up with all of this. Of course, Robert Beavis, the owner of Law Weapons, the chief plaintiff in the case Beavis v. Naperville. How's he holding up with all of this?
So Robert Beavis, we've mentioned this before. He has run into great difficulties keeping his business going. Last time I talked to him, his business was hanging on by a thread. It's very challenging when the state and when the local government first. So he's in worse shape than the rest of the gun dealers in the state, because Naperville started in on him first. When they ban what consisted of the majority of your product. So he is also a gunsmith, and he's been looking for ways to continue to serve the people of Naperville and Illinois. But it's been a struggle. It's been a real struggle for him.
And then to the timeline of all of this, you've got these 3 cases yesterday filing to the U.S. Supreme Court from Illinois, stacked on top of the Maryland case challenging gun bans in that state's now in front of the U.S. Supreme Court, asking for them to review. Are we going to see a quick turnaround on the U.S. Supreme Court taking one or all or consolidating these cases? What does that timeline look like? Again, Hannah Hill from the National Association for Gun Rights.
Well, this is the waiting game. This is not the fun part. And when it comes to a petition for cert at the Supreme Court, you can be waiting for months. So, for instance, Bruin itself, it was filed in December, the petition for that. It was filed in late December. It wasn't until the following April that the Supreme Court granted cert. And that is what I would kind of consider a short turnaround. It can take months and months. It can take a year. We hope it won't. And we are glad to see, the Bianchi case out of Maryland and all the other Illinois cases. We hope that this will up the urgency for the Supreme Court. But they're not on a time limit. They're on their own time, so they can take it whenever they want to. And it is also true that while they will have to eventually weigh in on this issue, because this is core to the Second Amendment right, and if they're serious about what they said in Bruin, they're going to have to take this specific issue of assault weapons bans at some point. That said, just by way of example, there were a lot of bump stock cases that got appealed to the Supreme Court before the court finally took one. The most recent one, Cargill versus Garland. So we hope that won't happen here. But I do think that if the Supreme Court decides to delay it, we'll be very disappointed, especially because we had hoped that this particular court would recognize that a right delayed is a right denied. They've already dragged their feet a lot on this very issue. We think that they should have taken at least one of our emergency appeals and provided at least a temporary level of relief. But if they're not going to do that, they need to take one of these cases, preferably all of them, and they need to weigh in and to smack down the lower court's defiance of what they said in both Heller and Bruin.
So again, that's Hannah Hill from the National Association for Gun Rights in a conversation I had with her yesterday, as a stack of lawsuits now in front of the U.S. Supreme Court requesting that they actually review and hear these cases. Let's just take a brief look here at some of the filings that have been made. And this is, of course, looking at the documents, the Harold v. Raoul case that was filed yesterday. Questions presented: whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their home with semi-automatic firearms that are in common use for lawful purposes, whether the Constitution Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with ammunition magazines that are in common use for lawful purposes, and whether enforcement of Illinois' semi-automatic firearm and ammunition magazine bans should be enjoined. So those are the questions presented in that particular case. What about the case that the National Association for Gun Rights and Robert Beavis have against the state? The questions presented: is the state of Illinois' ban of certain handguns constitutional in light of the holding in D.C. versus Heller that handgun bans are categorically unconstitutional? Is the in common use test announced in D.C. versus Heller hopelessly circular and therefore unworkable? And can the government ban the sale, purchase, and possession of certain semi-automatic firearms and firearm magazines that are possessed by millions of law-abiding Americans for lawful purposes when there is no analogous founding-era regulations? Let's take a look now at the Barnett case that was filed for cert in front of the U.S. Supreme Court. This as well has questions presented. In 2015, a divided Seventh Circuit panel held that states should be allowed to decide when civilians can possess firearms that they deem in their discretion to be, quote, military grade, so long as they leave their citizens with other adequate means of self-defense. Friedman versus the city of Highland Park. The future author of New York State Rifle and Pistol Association Incorporated versus Bruin lambasted that decision as flouting this court's precedents and relegating the Second Amendment to a second-class right. Goes on to say, yet after Bruin seemingly interred the reasoning of decisions like Friedman, and Illinois responded not by confronting existing law to Bruin, but with defiance, banning upwards to 1,000 previously lawful rifles, pistols, and shotguns, plus their respective parts and common magazines. A divided panel of the Seventh Circuit resurrected Friedman, declaring its approach not only basically compatible with, but more useful than Bruin, which is derided as slippery, circular, and not very helpful. The majority then took its disregard of Bruin one giant step further, concluding that Illinois' sweeping ban does not even implicate the Second Amendment. Not surprisingly, the decision drew a sharp dissent and created a circuit split to boot. The question presented is whether Illinois' sweeping ban on common and long lawful arms violates the Second Amendment. So again, you can kind of see there some of the arguments that the plaintiffs are raising in these cases that they have filed to the U.S. Supreme Court. And what happens next is going to be interesting, especially when you look at, as Todd Vandermeide shared with me this morning on a phone call, and he talked about it with his most recent video, and I expect to see more from Todd Vandermeide, Freedom's Steel on YouTube, about the Cargill case and the bump stock ban and the challenge against that. And then you get into the ultimate definition of what's a semi-automatic firearm. And if the ATF is going to say, hey, we need bump stocks to be banned because it converts a semi-automatic firearm into a machine gun, then, you know, if the government's saying that these are semi-automatic firearms that are allowed and a bump stock converts that to a machine gun, then, you know, if that's the argument the government's taking, isn't it kind of on the opposite end of what the Seventh Circuit said about AR-15s being, you know, military grade machine guns? So you look at how all of this interconnects. It's going to be a fascinating ride, and I hope that you guys stay with me here with Bishop on Air each and every weekday morning, chiming in, giving you the latest that you need to know, talking to the experts. So hopefully it has been informative and enlightening as to where we go from here. So I greatly appreciate you guys being with me each and every weekday morning. Be sure to like, subscribe, hit that notification bell. That way you can know when we go live. And if you miss any of the live sections, then you can go back and watch the recorded stuff that we upload. So I appreciate you guys being here each and every weekday morning. Again, follow me anywhere. Just search Bishop on Air. All one word, Bishop on Air. Check out the website, bishoponair.com, and we'll be back with more, as always, here with Bishop on Air. starting up the Discord. See if you guys want to sound off on this. Just take a few moments and get you guys in here. So if you want to, you can. Looks like we connected successfully again. So appreciate my live streaming and my internet for whatever reason being stupid. Let's do it. All right. So get your hand raised, and I see there's 5 people, 6 people now in the staging room. So if you want to sound off, raise your hand. Everybody from Craig to Randy to Warsaw, Dave the Hunter. If you guys want to, please do raise your hand. Tenebris as well, jumping into the staging area. So we've got 8 people. Who wants to sound off? Who wants to have their voice heard here? Especially considering that we've got the 4 different filings in front of the U.S. Supreme Court when it deals with gun and magazine bans. Bueller? All right, let's see if we can just invite Warsaw. I know he's got stuff to say. Warsaw, join in the conversation here. What do you think about this? Are we looking at a quick decision from the U.S. Supreme Court to take these cases, or how do you see this playing out?
It's hard to tell, to be honest with you, Greg, especially they've had multiple attempts and they've been just giving us a brief like, hey, not now, but we'll give another option. But honestly, at this point, I'm hopeful because it's not just Illinois. There's like 9 other states with more bans coming left and right, and even other states that are proposing them. So, I mean, the more bans and regulations and restrictions that are coming out, they have to take us up. I mean, it can't be ignored anymore. I mean, there's going to be so many complaints from all every state. It's not just Illinois.
Well, I think what's different, though, with these requests is these are on the merits. They're asking for the U.S. Supreme Court for a writ of certiorari, which means we want a hearing on the merits. Different from what the Beavis cases had previously done. They were asking for injunctive relief immediately, which was not a hearing on the merits. So now it looks like these 3 cases, all from Illinois, and then you've got the Maryland case, asking for a hearing on the merits.
Yep. Or gun ban regulation we have in our books, but Maryland, if people don't realize, Maryland actually has a serious case, actually colon cars. The FOIA card had it system for like 1986 as their version of a FOIA. Actually, rule and theirs actually requires fingerprints. So apart from our gun case, Maryland's actually is going to open up Pandora's box hopefully soon for Illinois too.
Well, yeah, you have several cases in appeals courts as well that open up the possibility of Illinois' firearm owner ID card being struck down. And there is that case that we'll be tracking it here in Illinois. And as far as the FOID card challenge, and that's in the Southern District of Illinois. Warsaw, appreciate you chiming in. Let's see, Craig, you're in the staging room. I'm going to invite you to speak. So good morning if you are in and ready to share your thoughts. I would love to hear it here with Bishop on air. So go ahead and jump on in there if you can. Accept that invitation to speak, and we'll see if you can chime in. We've also got several others, Randy, Dave, Soupster, Tenebris. If you guys want to be able to chime in here, let's see if I can invite you to speak. Craig, then pop in. And I'm still new to this Discord thing, so I'm still kind of working the bugs out, trying to understand how this works ultimately. So appreciate you guys taking the time in the post segment here to sound off. Let's see, Craig. It doesn't look like you're joining in here, so let's go and check out what Tenebris has to say. Tenebris, I'm gonna invite you and see if you can pop in here and sound off. So let's get you in. We got you guys pumping through here, or what? No? All right, Tenebris, looks like you are joining now. So good morning. What are your thoughts on this?
Good morning. And another good show, Greg. I love listening to you every morning. I have a good feeling that they're gonna step in here and grab this. Like Warsaw said, there's too many states involved now, and they haven't, as you mentioned, they haven't really addressed this. All these previous cases weren't addressed on the merits, and I think, what was it, Bianchi, Firearms Policy Coalition, Gun Owners of America, they made some pretty compelling arguments. that, these were rights that were being denied. And like Hannah said, I think this court realizes that a right delayed is a right denied. I think they're going to step in here. I hope sooner rather than later. I'd hate to wait until the middle of 25.
Well, I mean, you've got the Maryland case, but you also have a case out of California as well that seems to be ripe for heading to the U.S. Supreme Court. But I think one frustration a lot of people have in observing all of this is how quickly states can go about passing these types of laws and enacting these types of laws, because Illinois, it happened within the span of, 2 or 3 days, and then the ban went into effect immediately. But here we are now, more than a year afterwards, and still dealing with this case.
And, I see a lot of stuff online where people question if we have any recourse to sue politicians or judges or charge them with a violation of their oath. I don't know that we have anything like that. What can the Supreme Court do? Can they censure an inferior court?
That's a great question. I don't know that answer. I would imagine simply having a ruling that blasts the lower courts could be considered somewhat of a censure, but who's to be held responsible for courts making poor decisions that don't align with what the U.S. Supreme Court has to say about things? Good points there. Tenebris, appreciate that. Going to see if we can get another voice in here as well. Let's see. Let's do Dave the Hunter. Dave, if you're ready to chime in here, let's go ahead and get you in. And you're now up. Dave, what's up?
Yeah, good morning. My thing is there's no potential repercussion to the politicians that create these unconstitutional edicts, laws, that we wind up having to pay for the defense of, and then we also wind up having to pay to have it then overturned, and there is absolutely no repercussions other than the potential to get them taken out of office the next general election.
Yeah. And Warsaw sent in a chat here saying a civil court that violates the Supreme Court fee needs to be held accountable by the federal judiciary. We need to all contact Jim Jordan and the federal judiciary to have a hearing on this. That's an interesting thing I've heard proposed elsewhere as well, to have congressional hearings on how the lower courts are the inferior courts seem to be thumbing their nose at the Supreme Court. And that's something that even Alan Gottlieb said he believes very much these lower courts are doing. And even the Barnett filing really levels into that hard, saying that, they seem to just kind of be going off on their own, the lower courts, when it comes to Supreme Court precedent. I don't know what the answer is there, Dave, but I appreciate you chiming in. Let's see, Brock, let's see if you want to chime in to speak here with the Discord channel. And again, if you want to join the Discord channel, it's pretty simple. You just go to bishoponair.com, click the Discord link there, and you should be able to get in, and then you follow through to your calls where you can chime in. So I've got Brock. Let's see if he wants to get in here to have his voice heard. So Brock, I think you have to accept that invite. If you don't, I'm going to go and see what Soupster has to say. Soupster actually being the first one that we had test the Discord channel, so it's good to see him back in here. Soupster, what's going on, man? Checking 1, checking 2. Check that mic. Soupster, are you there? I can't hear you if you are talking. So we'll see if we can give that another shot here in a bit. Brock, let's see if we can go back to you as we take some phone calls here live. And do we even call these phone calls? What are these, Discord calls? What do we characterize these as? That's a good question. I'm not too sure. All right, so Brock doesn't seem to be coming through. Let's go to Randy. Randy, I'm requesting you to jump in here. So yeah, there you go. Randy, what's up? What are your thoughts?
Hey, good morning, Greg.
Good morning.
Doing?
Good.
Yeah, I used to have that problem, but then I moved. I've been a proud citizen of Alabama since 2013. I moved from Illinois to southwest side of Chicago. I grew up in unincorporated Cook County, and I got my LFOID when I was 18, 19, and I think I re-upped it once, and after that, I kind of let it go by the way. I was still carrying every day. I've worked in gas stations where, well, until I got robbed the first time, I didn't carry, and after that, I never got robbed again. But besides all that, I think your governor has overstepped his authorities, so to speak, because he got Bruin reinforced by reinforcing Heller, and then he's going to come up with this. It's just a big waste of time. 2 years later, it's going to get shot down. That's my thoughts on it.
Well, I appreciate that, and we'll be tracking this all the way through. But I guess if you could kind of give us a difference in the culture of those who look at the Second Amendment as a civil liberty. Do you see that more so now in Alabama compared to what you saw when you lived in Illinois all those years ago?
I go to gas stations around here, and people open carry. A lot of ladies. I mean, a lot of ladies open carrying down here, my wife included. Well, she's got two, but anyways, yeah, training is probably the key thing. That just to have something to protect yourself is one thing, and being able to use it is another. I mean, there was an incident about 7 months ago at an IHOP about 11:20 something in the morning, and yeah, a guy wasn't too happy with his food and started shooting at the cook. Well, unapologetically, he had to be stopped from doing that. So I promptly did that, and yeah, it was not an issue.
Wow. Wow. Well, you mentioned a lot of women carrying and even men carrying, what do they call it? The great equalizer, right? Where a firearm can definitely make the difference in if you're being attacked to a degree. So interesting to hear that story, Randy. Appreciate you chiming in this morning. All right, guys. I think the Discord server is working as I hoped it would. So if you want to be able to take part in the program, again, go to bishoponair.com, click that Discord link, and you should be able to just follow through. And if you're already on Discord, you'll be able to just plug right in, go to the Bishop on Air server, and then during the program, we'll open it up for phone calls from time to time. So I appreciate you guys taking part in that. But I got to get out of here. All right, full day of work ahead and plenty for us to talk about tomorrow. So we'll be back at it. And we'll hear what maybe the governor has to say. He's got a couple of events today. So will he be asked about these filings in front of the U.S. Supreme Court? I'll share that with you as soon as we get that. So appreciate you guys being here each and every weekday morning. It's Bishop on Air. I'm Greg Bishop, hanging out with you. Hit that like, subscribe, notification bell, and make it happen, all right? We'll see you back here bright and early tomorrow with Bishop on Air. I appreciate you, Bob, Keith, Carla, Cordell, JL, CNT Design, Light Pole. All right. You guys being here each and every morning make my day. So appreciate it. We'll see you back here tomorrow morning. All right. Puffy Elvis? What kind of name is Puffy Elvis?